It is 8:51 a.m. Today is Friday, October 6th. We have a long day of work sessions. We're starting early. Thank you, everybody. We are here to discuss proposed AO 2023-100, an ordinance of the Anchorage Municipal Assembly amending certain provisions of the Anchorage Municipal Code, Title 8 Penal Code, to update and amend sections for consistency with statute amendments. Go ahead and start with introductions. Mr. Martinez.
George Martinez.
Felix Rivera.
Zach Johnson.
Karen Bronga.
Scott Myers.
Meg Zalato.
Christopher Constant. And on the administration, we have
Dustin Pearson, City Prosecutor.
Mario Bird, Chief of Staff.
Mia Costello, Director of Legislative Affairs.
and that's Ann Helzer, Municipal Attorney. You have extra mics over here. So I don't know who is intending to present today this item for discussion. So we have Member Salt and Member Bronga. Member Salt is not here, so I think Member Bronga, the floor starts with you.
I really thought Ms. Costello was going to take this, but I was approached if I would sign on to this. SB 91 was led to a spike in crimes in the state, and apparently Ms. Costello was part of the original passing of that. But when they realized what was going on with crime in the city and state, it was rolled back by House Bill 49, which you were also a part of, correct? And that passed in July of 2019. And what happened was an inconsistency between the state and the municipality in penalties for failure to appear. And so this AO would put failure to appear from a violation to a misdemeanor. So it would basically correct just an oversight that would hopefully, and I would be nice to know such things as how many people are failing to appear, how much this is actually affecting. But to my mind, it should be consistent with the state. And Ms. Costello, is there anything that I missed?
Ms. Costello.
Thank you. Through the chair, Assemblywoman Bronga. No, I think you gave a good overview of the history, and we have the municipal prosecutor here who can walk us through what this actually does and the changes that it will have in terms of the day-to-day job of our criminal justice system.
Okay. My name is Dustin Pearson. I'm a city prosecutor. What I can tell you is that the way we ended up here was through a system of responses, if you will, to outside forces. And so when this SB 91 passed, all of a sudden we had laws on our books that were claimed that certain things were misdemeanors, and under state law they were now infractions. And so it looks like under an emergency sort of situation, we pulled back the VCR, violating conditions of release, and the FTA, the failure to appear, that we're dealing with now. Now, when some years later, and that was done, it looks like more or less immediately. And again, this looks like in the context of an emergency order to which it was an emergency. We had things on our books that were crimes that were no longer crimes. And so those things were pulled down kind of hastily. When the House bill that brought these things back into crimes, again, we were responding to the state and the change in circumstances. I wasn't party to that discussion because I was a line attorney at the time, but our primary, from prosecution, our primary concern at the time was bringing back criminal penalties for the violating conditions of release, because at least as how things operated at that time and how they operate today, that made very significant immediate impact to public safety, in the sense that during SB 91, part of the public outcry and our outcry as an office was that people were being ordered by the court not to do certain things, like don't go back to victims' residences, or don't possess, consume alcohol, don't do new crimes. And the police would catch those people, and instead of charging them with a new crime, VCR, and bringing them to jail to see a judge, they would simply issue them a ticket, and because it was an infraction. And unless they were doing some other new crime, like a new assault or a new theft, they couldn't arrest them, even though they knew they were violating court orders. And so that got recriminalized quickly, as it should have. For whatever reason, the FTAs did not. And what we're doing here today is bringing that back into line, the same as we should have back then with the VCRs. Now, as a bit of background for folks that aren't super familiar with the criminal system, the question of, is this going to result in new arrests or new people facing increased jail time or anything like that? The background that you need to understand is that the court issues bench warrants for people every single day. For several years, this has not been a crime in the municipality, it's been a ticket. But people are still, when people don't show up to court, the court issues bench warrants, which are civil issues. Again, they're not charged with crime because this wasn't crime. The court attaches dollar amounts to those bench warrants. Under the judge's discretion, they base that on their criminal history. They base it on the charges that are in front of them in that particular case. And the judge comes up with something between $0 and thousands of dollars, depending on the situation. And the judge says, you weren't here today. I'm issuing a bench warrant for your arrest. That's separate of any question of whether we're charging a crime or not. Those people are then found by the police at some point. They're arrested and brought to jail, and they're held until they have a bail hearing or until they post that bail. And so that's what's been going on for all these years. That's what will continue to go on. The question of whether we're able to charge crime with that later is a separate question. And it would be somewhat speculation going forward as to me to promise you what certain numbers of cases will be charged or not. But what I can tell you is that I can speak for the last 12 years that I've been here. When it was a crime before, it was not something that, just because someone gets a bench warrant doesn't mean they're going to be charged with FTA. That wasn't the case before. It was something that was done fairly rarely, and it was done something deliberately by our prosecutors, given the circumstances. The reality is that to my knowledge, there's never been a time where charges for FTA were automatically filed every single time a person gets a bench warrant. There's probably hundreds of bench warrants a week that get issued by the court. And so there's not going to be thousands of FTA charges out of the floodgates here. The reality is that, and especially there's some background issues with the current court practices with COVID, we wouldn't be able to charge most of these failure to appears anyways, because we wouldn't be able to prove them in court, given how people are appearing remotely or not at all these days. But what it would be an opportunity for my people to have a tool in their tool bag. Because at the end of the day, the few times we did charge it previously was when people had absconded for lengthy periods of time or had repeatedly absconded. And at the end of the day, they're compromising our ability to prosecute their case. When cases age, they get harder to prove. Witnesses' memories become more faulty because you're talking about something that happened years ago instead of months ago. People's motivation to cooperate with us changes over the time if you're talking about a DV type case. But so the reality is the older a case is, the better it is for the defendant. And if the defendant is doing that by not appearing and dragging their case on, that's when we would charge those charges previously. And that's when we would anticipate charging them here in the future. Is that if someone, so it would be a choice that my prosecutors are making based on the circumstances, based on that particular defendant. And historically, there was maybe a dozen or two charges a year probably filed for FTA. And those were primarily filed when someone's, demanding a trial, and we're there and we say, well, if you want to put up, here we go. You've dragged your case on. We're going to charge you for these bench warrants, and here's your new charges. It's not something that happens as a matter of course, or it's not something that happens excessively.
So I have some people have questions. Ms. Zalatil.
Thank you. So when I saw this pop up, and I wasn't sure if it was going to be at the Public Safety Committee meeting, I asked a couple of questions. Thank you for answering my question. Really kind of what would possibly change. And it sounds like this would be a very narrow tool in your toolbox. I think for a little bit of background, going to court isn't really a thing anymore. It's hard to go to court sometimes unless the court demands your presence there. And often, particularly in civil matters, you have to request to go to court. Otherwise, they would prefer you either use their electronic means or their telephonic means. And I think that's really important for us to have as a part of this conversation, because the landscape has changed. And unless you are practicing, you probably don't know that. So I asked Chief Curl kind of what do we see for FTA or failure to appear citations. And he said since January 1, 28 people received 30 citations. So 2 people were cited twice. So I guess this really drives the question, I guess, to Ms. Bronga and Mr. Solt, who are the sponsors of this from the Assembly. what is your expectation with this proposed code change? Like, it seems very narrow as to the effect it will have on the number of people and the amount of times it will be used. So I guess, why are we taking this up, and why are we taking this up now? Thanks.
Ms. Bronga.
Well, we are basically fixing an inconsistency with the state, is the way I understand it. And as the prosecutor described, it is a tool in a toolbox. If we have someone who is dodging that court trial, it will be a way to basically motivate them to get to it. I don't know if this would have the same effect, but I went to a hearing recently, and the individual refused to leave the cell to come to the arraignment. So I don't know if it could be used in cases like that, but I think that there's a lot of time and energy to get a trial together. And if we are having people who are just refusing to come, it has to comes at a cost. So basically, just another tool in the toolbox to get people to appear, and whether it's telephonically or whatnot. We've made it very easy to appear to court. And so, Mr. Byrd, did you want to, were you going to add to that? Okay.
I have a pretty long queue.
Hold on. I wanted to give Brandy the same opportunity. He's on now. Is
Yeah,
that
I was
okay?
going to say when we had a second that Ms. Brawley joined us approximately 8 minutes ago. Mr. Salt is with us as well. Mr. Salt.
Yep, thank you, and apologize for running late. So another thing this does is when SB 91 was repealed, a lot of the muni code was aligned with state code. This is one of the artifacts of that is not aligned. So this also brings us in alignment with state.
Okay, thank you. So I'm hearing it's to fix an inconsistency with the state, and as possible tool at trial. I'm just going to put the question out there, maybe it'll get covered, is I guess I would like to know when we would use this versus seeking, or when the judge might just issue a bench warrant, because that is something that's already routine, and it's not something we then have to prove. Thank you.
All right, so I have myself in the queue, Mr. Johnson, Mr. Rivera, and then Mr. Byrd. So I am agnostic on the actual policy change at this time. I have yet to make a conclusion. The argument that it's inconsistent is a reasonable argument. I don't like the actual narrative of the AM, and so I'm probably going to try to draft an alternative AM, because what this does is passively suggests that the passage of SB 91 actually created the spike in crime. And those of us who are on the ground in this town know that what actually created the spike in crime was the Senate's reticence to fund the community-based supports that the Texas model was based on. And so when they claimed that they implemented the model that Texas had done, it was just a bald-faced lie. What they did was they closed the jails and they didn't fund the services. And so the people ended up on the streets of our town. And so I am not a fan of how the memorandum or even the whereas statements in this thing are written, because what it suggests is that criminal justice reform created a spike in crime. No, it was a failure of leadership in the legislature that created a spike in crime. And so that's kind of tangential to the actual policy change. So again, as I said, I'm agnostic to that and can be convinced, but I will likely be coming forward with an alternative statement of facts. So Mr. Johnson.
Yeah, thank you. Question and then possible follow-up. I was told that the state statute for failure to appear is in fact a Class A misdemeanor. Is that correct?
I'll be honest, given I don't charge things under state statute ever, it's not something I keep abreast of. But I think
And if we want, we could maybe
Yeah.
research this a little bit. It was something I was told, and we can, I don't know if we need to pause everything while we
No,
dig
you're-
into this, but I might circle back to you.
For
It's
sure.
not, that information is not close at hand.
Totally. My understanding, whether it is or not, I think that the primary distinction we're trying to bring is that it needs to have criminal consequences to it as it used to. And if we're being more lax than the state still and only having it be a B misdemeanor or 90-day maximum, we're still attaching consequences to it when we choose to seek that.
I agree with the principle that there should be consequences and criminal consequences seem appropriate. But as part of our, stated goal here seems to bring municipal code in alignment with state statute. Just if we are doing something different from the state, I would just, I think it'd be worth having a conversation about why we would choose to go that route. I'm not planting my flag that we necessarily have to follow the state code, but again, if there's a discrepancy, I think there should be a reason for it.
My read of the statute, and I'm no attorney, but it suggests that there might be different tiers under the statute depending on the nature of circumstances. So it might be one of those, it depends answers. Mr. Rivera.
Yeah, thank you, Mr. Chair. So I appreciate some of the discussion so far. I will just bluntly say that I am skeptical of this ordinance. And the argument of inconsistency for me is not a strong one. So I guess just a few basic questions. So we're looking at, if I heard correctly, approximately 12 to 24 cases. I think you said those are pre-SB 91 cases of failure to appear. Was that correct?
Me making broad statements about the 12 years ago, yeah, I would say it was very infrequent. It was, and usually at trial, in essence. And so it's not new cases, it's counts being added to already existing cases. But yes, in the realm of dozens is what I would say. 1 or 2 a year would be average.
Okay, thanks. And do you know why people fail to appear?
I'm sure there's lots of reasons, and there's lots of, Alaska's a unique place. I've been here for 12 years now, but we have situations that arise. People come here seasonally, people come here, every couple of years to visit family or something like that. But our remote nature makes it so that people show up here and interact with our criminal system and then aren't living here. I think that happens way more frequently here than other places. So there are times when there are very lengthy bench warrants that are out for whatever reason. There are plenty of instances where there are very brief bench warrants where people have repeated contact but fail to come to court. At the end of the day, why someone's not coming to court is something that's not, I suppose it's a defensive source depending on their situation, but I would say the times that we even contemplate charging it is when it is fairly egregious. And again, this isn't something that was done as a matter of course. Again, the court issues bench warrants every single day. There's bench warrants being issued this morning for people not coming to the court this morning. There'll be bench warrants issued this afternoon for people not coming to court this afternoon. The court does that routinely, and that's a civil matter, but that results in people going to jail. I would point out that when we choose to charge somebody later, it's not resulting in them being snatched up and brought to court to come to the judge, because that's already happened in the context of the bench warrant. What we are trying to do when we decide to charge somebody with FTA is we are looking back at the conduct that's led up to this situation. And again, we're not looking to make more work for ourselves. We're looking to help enforce the law and norms. And so when someone has an underlying charge like a DUI or an assault or something, and they say, no, I want to fight this, I want a trial, and that's fine, that's their right. But we also should have the ability to enforce the law, which means that if you've made my case terrible by being gone for a year and a half, or you've had 8 bench warrants during the course of your case and you've dragged this case out forever, that's when we would look at that and say, well, you've compromised my ability to prosecute the underlying charge, but you have also done that deliberately or not. I'm not going to intent, but if you have benefited by doing this, that's when we would look at that and say, well, if you want to do this, then we will seek that. And then at that point,
Thanks.
if they're convicted of it, then they would be
Thanks.
sentenced. But
Yeah, I think you've addressed my question,
Got
and I just have I'm conscious of time. I have a third one, and then I'll just leave it at that, Mr. Chair. So again, taking yourself back to pre-SB 91 days, if someone were to be charged with failure to appear, what happens?
We will basically they already have a case. We're not getting a new case. The officers don't get a warrant and open a new case for a bench warrant because there's already a warrant out there. They'll just arrest them and bring them back to jail on that original charge. So what happens is we give them a charge. Usually we're at trial and we're about to start their other case, their other charge, and it would be a totally separate trial. Honestly, it would be a totally separate sentence, all under the same case number because we're adding that to the underlying case. And if they've decided to play ball that way and go do that, then they'll have additional exposure. And whether that results in additional jail time to serve on top of whatever the charge, that's up to the judge. But it's not resulting in people getting proactively snatched up for something new and getting a new case file started and all that stuff. It's not creating work in that sense. It's just acknowledging the reality of what's happened during the course of this case. And the most important part to me is as a prosecutor is the fact that judges look at criminal history when they decide bail in the future. And so when this person, however this shakes out, gets a new charge next year, next month, whatever, when the judge decides what a reasonable bail is, they look at their criminal history. And right now, the part of that is if someone's not getting convicted for the FTA, it's not showing up on their history. And people failing to appear constantly. Next time this person gets a charge, their bail will reflect the fact that they've been convicted for failing to appear. And the judge will see that this person poses a risk of not coming to court, and they should set their bail differently than seeing the blank criminal history. And so that's, for us, it's a compounding problem in the sense that when these are tickets, they're not tracked in any sort of way, and the judges aren't able to correctly ascertain whether this person's failing to appear is going to impact their ability to come to court in the next case. And so their bail doesn't get set appropriately.
Thanks, Mr. Chair. If you can add me to the queue again.
Mr. Gates.
I thought I was way down the queue. Thank you, Mr. Chair. I might add a little context, I think, from my perspective of this ordinance and the change. I was asked by Mr. Solti to watch for this change in ordinance coming from the admin for fixing the SB 91 repeal changes to our code. And that when it came forward, I did some review and research, just cursory, but I emailed Dustin and Mario here and Mr. Solti, and I apologize. I didn't include Mrs. Braga in this view, but one thing that I showed is SB 91. One thing it did, in addition to, I guess, hundreds of others, is amended our Title 29 municipal government section of the state statutes to say that the municipality cannot have a greater penalty for a criminal offense than is in state law. So that was a new subsection that put limitations on home rule municipalities. So our ordinance, I think it was 2016-83, which changed much of our criminal code and our English municipal code, lowered some penalties to be consistent with what SB 91 changed for state law. So when some were repealed, we went back. But one thing that stood out is that new section that limited municipal governments. It said we can't have a greater penalty, so we can have a lesser penalty for a criminal offense. And all this to sort of say, from my point of view, this ordinance changes the failure to appear penalty from minor offense to Class B misdemeanor. The state statute, as someone noted, has a Class A misdemeanor for a couple of situations. If you fail to appear when you're charged with a misdemeanor, or fail to appear when you're a material witness subpoenaed for a criminal case. We don't have that second part in our code. We have the first part. So we're not exactly identical to the state statute. And we are making this Class B misdemeanor, not a Class A misdemeanor in our code. So we're not identical to the state statute, but we are consistent. So I think you can make a public policy decision to leave this offense as a minor offense, which was what SB 91 did with the state statute, but they changed it back to Class A misdemeanor. We're changing back to Class B misdemeanor. So a public policy decision, you can leave it a minor and change to Class B misdemeanor, change to Class A misdemeanor, but you couldn't have a greater penalty.
I have a number of people in the queue, Mr. Gates, but it also says it's a Class C felony under the state law if the person were released in connection with the charge of a felony while waiting sentence. I understand we don't really charge felonies. The state manages most of that, but on occasion we might, because the state might opt not to prosecute, and they might ask us to step in. I think I've seen that happen a time or two. And so what I just heard you say was that we can't have a higher standard than the state, or not standard penalty, but in fact, there is a Class C in there. So are we out of alignment with the state by going with the Class B?
If I could respond real briefly, or clarify, I guess. The municipality does not have the authority to charge felonies.
Not
We-
charge them, but sometimes we've had to prosecute them.
As misdemeanors. Like, we don't have the authority to appear in superior courts. And so definitionally, the only business we're in is misdemeanors. So we have the same thing with violating conditions of release. That's also varies depending on the initial charge, but we don't have the authority to charge felonies.
So Mr. Gates, does that align with your perspective?
That we don't have the authority to charge felonies. Yes, and that's been historically since we became a municipality.
So then the answer to my question to you would be, it's kind of moot because that we would never have that issue here.
I'm not sure if I understand what would be moot.
The fact
We
that
can
there is
still
a
charge for
Class
B
C,
misdemeanors.
the fact that there's a Class C in the state statute, ours is a B, it isn't going to inherently be in conflict with that state law that says we can't charge a higher penalty.
Well, we wouldn't be charging any higher penalty than is in state law, so I guess what my point earlier was, our failure to appear ordinance is not identical to state statute. It's still not going to be identical after this change with the whole state statute, or even just the one subsection that we have, where we have the same corresponding charge. So I guess there's two types of charges under the state failure to appear: the Class C felony, if you fail to appear after you're charged with a felony, or if your felony conviction's on appeal. And we don't have that. We don't have the ability to do that.
That's okay. That's what I needed you to say. Thank you, sir. Mr. Byrd.
Thank you, Mr. Chair. I just wanted to clarify some of the questions about why the administration is bringing it forward now, and what the purpose is from the administration's point of view. First of all, I know that this has been an idea of the mayor and the administration, I think, for over a year.
Point of order. I didn't ask for the administration's point of view on it. I was asking why my colleagues were bringing it. I don't really care why the administration's bringing it forward. I read it in the AM. I kind of got your point of view.
I think great care is in order to not put words in members' mouths. You'll still have the floor and you can make your point because this is the administration's opportunity to present with the members, but it's great care.
Thank you, Mr. Chair.
And here's how I would suggest. I would just suggest, instead of saying to respond to members' questions, I would say the administration's perspective is this, right? Because just from a procedural matter, it looks like you're responding to questions that weren't asked.
Understood, Mr. Chair. So the administration's perspective is this. I think this is something that the administration has wanted to do for some time to realign municipal code to the pre-SB 91 stage. I think the acting municipal prosecutor has made it clear that it is a tool in the toolbox, and I think the practical effect that the administration sees as a benefit for the citizens of Anchorage is this allows them a greater amount of leverage when it comes to getting to resolution and disposition of cases. Most people know that whether it was COVID or whatever else the backlog that's been referred to, municipal prosecutors need all the tools that they can to get cases to resolution. And I think the body has already heard from the municipal prosecutor that it's infrequently used, but it's used with a purpose. We want to give all the tools that we can to the prosecution team, and we think this is a good way of doing that. I also think that the administration wants to make sure that the public has a right to see people who are been accused of committing public offenses, that they are tried in a public manner, and that's the substance, I guess, of this offense. Whether or not somebody is required to appear, we think that it's important for the public that if they decide for whatever reason not to appear, that is something that there are consequences for. Thank you, Mr. Chair.
Thank you, Mr. Byrd. I have quite a queue. I have Ms. Brawley, Mr. Martinez, Mr. Rivera, Ms. Costello, myself, Mr. Johnson, Mr. Salt. We have, I think, half an hour. So the next will be Ms. Brawley.
Yeah, thank you. I have a couple of questions for the prosecutor. It was things you had said, and I guess maybe like what I'm hearing from other colleagues, trying to understand what impact this will have, what positive impact, and I understand it's probably going to be limited. But my first question is in terms of your caseload. I remember, you've presented several times on having low staff and a large number of cases. I'm just wondering how, in your overall caseload, what percent would this in a typical year include this particular situation?
The times this has come up previously and the times I anticipate this coming up in the future is when cases are at trial. And so this is, again, we're not in the business of making more work for ourselves. So people will continue to get bench warrants every single day. We're not going to be charging this every single day. This is going to be the tip of the iceberg where someone has refused to, hopefully we never have to charge this, because hopefully the threat of additional charges will help motivate people to resolve their cases, the underlying cases. We're not here to convict people of FTA. We're here to convict people of assaulting people, of driving drunk, of stealing people's stuff, of doing crime. I mean, that's also why I'm not super interested in whether this is a misdemeanor or B misdemeanor, because I'm not in the business of convicting people of FTA. So the point of this is to help us get those underlying charges resolved. And so the times we would be adding this on is when people have pushed for trial, which trials are starting back up again. They've been starting back up again for a while, but this is the rubber meeting the road now, and this will help facilitate down the road us resolving these other cases, the actual underlying crimes. And so again, a handful of times it'll be threatened to charge when we get to that trial point, which again is the tip of the spear, the top of the iceberg. It's not all the cases. And then when people continue to persist and demand their trial, then we'll add those charges there. But it'll be something in the background and that's used sparingly, is what I would say.
Okay, thank you. And as I understand it, is it accurate that all of the cases that could be brought by the municipal prosecutor's office, the limiting factor is really the staffing and the time to deal with those cases? Is that fair to say?
We get what we get, and we work with what we got. And so how many cases we get each day? It looks like it's 10 new cases today at the jail court. That spigot we're not in control of, and we respond to it. And our staffing levels are a secondary question to what we have before us. So we have continued as business as usual. We will continue to continue as business as usual, and we will do what we can with what we got. But this will help us on the back end, closing things out, which will lighten the load eventually, hopefully, for my people down the road.
Okay, and one other question. You mentioned to jail. Can you clarify, because as I understand it, we don't actually have jails. I mean, we use that term, but can you clarify kind of how our prison system works and the fact that we have unsentenced and sentenced together?
Sorry, when I said jail, the Anchorage Correctional Complex. We have two ways the cases come to us. The folks that are, anyone that's arrested and is stuck in custody will see a judge within 24 hours. They will be put on the court calendar and brought before a judge for an arraignment. My people respond to that every single day, 365 days a year. Christmas Day, New Year's Day, I'll be down there. So anyone who's gotten arrested in the last 24 hours and is stuck in the sense that they haven't been able to post bail, they will get processed and brought before the judge that next day. And so our people are bringing those cases up to speed, making screening decisions on them, contacting victims, all of that between 8 a.m. and 11:30 in the morning every single day. So that's one input that we have is that, and that number varies. We're not in charge of that. We find out every morning. The larger number of cases is people that have citations. So not everyone that commits a crime is arrested and brought to the judge. Many of them get citations and they get future court dates that are 5-6 weeks out. And so we have a longer time to spin up to that, but that's also, we're not in control of how many citations are getting issued. But the folks that are being brought into custody from the bail schedule, it makes it so that it's DV crimes, number one, are held until they see the judge so the judge can set conditions of release. The folks that aren't getting straight up citations are folks that have repeat prior convictions. For on a first DUI, you get a ticket and they release you as soon as you're sober. If you have a prior, then there's some monetary amount attached to it by the schedule. It is the same thing with so many of our misdemeanors. If you don't have priors, or you're not going to jail, you're getting a ticket. If you do have a bench warrant, then that's not in your charge. We're not making a screening decision on that, but you are getting brought to court based on that bench warrant the judge issued for you.
Next in the queue is Mr. Martinez.
Thank you, Chair. A couple of clarifying questions. So today we charge FTAs and it leads to a fine. Is that accurate?
Technically, we're not charging FTA. The court is issuing a bench warrant for someone who didn't appear, and the court is demanding that police arrest that person and bring them back to court. Apparently 12 times out of the year, they're getting issued a ticket along the way. The tickets, the minor offense citations, we have no role in. So I don't know. Those aren't brought to us because they're not criminal charges. When you get it, it's the same as a speeding ticket. Basically, you get a citation from the police that says, here's the money you owe, and if you want to fight it, you can come to ticket court. But at no point is there jail on the table for that because it's not a crime. And the prosecutors aren't involved because it's not a crime. So,
yeah, that's a little straight from my question.
So we're not charging FTA.
Let me reset the question because I may have been off for the last 20 minutes now. From my understanding, I'm listening to the difference between where we are today, which is it's not a criminal offense, it's a fine, which is the same classification of the thing called FTA. Is that accurate or not accurate? So that today an FTA leads to a fine rather than to a charge. Is that accurate or not?
Yes, as of right now, it is a ticket.
So FTA today is something we do, in fact, exercise, but it leads to a fine. Okay.
Correct. Yes.
All right. Because it got a little complicated, but that was as simple as I needed it. All right. So what happens to the money associated with those fines today?
I have no idea.
Right on. And the next part of the question is, you mentioned the idea of, because there's two things that are kind of running afoul of just the logic statements here. And I understand code, bringing code into alignment. We're doing that in a variety of places with alcohol, municipal code, marijuana code. So I understand that whole kind of body of work. But the narrative that connects back to the public narrative of SB 91 and crime spikes is a really challenging one for me, considering how narrow we're talking about the subset here. So this is not a silver bullet of public rhetoric of a victory over crime, particularly. So, but the question that you mentioned, that you raised before, Mr. Prosecutor, was that tracking. You mentioned this idea of tracking, and you said that today we don't have the ability to track, but that if we change the code to a certain to this change that's being requested here, then all of a sudden we would have the ability to track. I don't understand that difference.
Okay. What I will
And maybe the difference is, in fact, that we're just not tracking effectively today. Like if we're charging someone with a $500 fine, we don't track that on the record, because you mentioned that you would like to see it on the record as an indicator for future notification to the judge in terms of the decision making, in terms of sentencing, in terms of just who this person is. You wanted to see it on the record, and I understand that point, but Why isn't it on the record today if we're charging $500 for the same overall offense? Why can't we do a better job on tracking that today?
As a prosecutor, when I appear in court and present charges to a judge, part of the reason we need a prosecutor to go to court is not only is that prosecutor exercising their professional judgment and whether to charge the case in the first place, the prosecutor is also reviewing that person's criminal history. Their in-state criminal history is tracked by a thing called APSIN, the Alaska Public Safety Information Network. And interstate, it's the NCIC, the National Criminal Information something. But so anyways, at prosecutors, we have special clearance to even look at these documents in the first place, but we get everyone's out of state criminal history if they have it. So we can see what charges they've had in other states and what convictions they've had in other states. And inside of Alaska, we see every arrest they've had for a criminal charge and whether that was charged or not and whether they're convicted or not. And what we present to the judge at the time this person is arraigned, because when a judge sets bail for somebody, they're doing so based on the facts of the current case that's being charged and based on that person's criminal history. Now, the term criminal history I'm using very precisely in the sense that only tracks things that are crimes. Now, that's why I didn't mean to quibble or the term FTA is used interchangeably with bench warrants. And again, a bench warrant is a completely civil matter. There's no, I mean, the court has the authority to do that. They don't do a show cause hearing. They would if they're going to throw you in court in jail for contempt. But the judge can set whatever bench warrant they want, and the remedy, if you think the judge is being improper, is to appeal that judge and ask for a reconsideration. You don't get it's not a new case. You don't have there's no new jail time or sentence attached to that because it's just a civil matter inside the context of that case. The citations are similar. They're not criminal offenses. We don't have the same way. I mean, DMV tracks speeding tickets is my understanding for the point of points and all that. But when I run someone's criminal history, I'm not getting every offense and ticket they've ever gotten. This person could have gotten 1,000 jaywalking tickets and speeding tickets and every other minor offense out there. None of that's coming back on the criminal history because it's checking for charges. Criminal cases that have jail time attached and the right to an attorney attached and the right to a trial attached to them. And so right now, however many tickets a person's gotten for FTA, that's not something that's being presented to the court because it's not criminal. And so my point is that if, again, this is something we're only charging in certain circumstances that warrant them. But at the end of the day, if that person ended up getting that conviction, then in the future, they would see that that person has a conviction for FTA. There are people with criminal histories with FTAs, but nothing since SB 91. And because it hasn't been a crime. So if you look at someone's criminal history and they have 50 prior convictions, they could have the whole spectrum of different charges, but for a certain fact, they will not have FTA convictions past when it was decriminalized with SB 91. I have not personally seen that many with the state. That's why I was personally unaware that the state recriminalized it because it's not something I've seen in my day-to-day. But I'm not the DA. I can't answer for what they're doing or not doing. But for my people, it's something that in the future, that's what would be tracked. And so that if that person ends up getting convicted for that, the same as all their other charges, that's something every judge down the road will be aware of, that this person was convicted of it, and I should take that into account when setting bail. Does that make sense?
I understand your answer.
We have a number of people in the queue. I'm going to reorganize the queue slightly. I have Mr. Salt because he hasn't spoken yet. Everyone else has once gone. Mr. Salt.
Yeah, thank you. So I appreciate the work session. Again, this was supposed to be a fairly simple, straightforward alignment to state code. As you heard, it's fairly minor as far as how often it's used. We did consult with Dean on what had been missed when SB 91 was repealed. And that's where it started. We had heard that some things were missed and wanted to correct that. Dean went through and basically narrowed it down to this one small aspect that he felt was a necessary change that we could make. And so that's what we offered up. I hear the whereases. I look forward to the amendments. If we want to include other portions around the Class C, obviously we can't do the Class A. Look forward to those amendments as well. But again, trying to make this very simple. And I also just want to, are you gonna get Ms. Helzer in, or do you want me to yield my time to her?
No, I saw that she wanted to be in the queue, but you said at the end. And so there's a number of people who are still in the queue.
Okay,
and so
good, thanks.
we aren't at the end. So, but I did note that that was a request. So, okay, now we'll roll back up. Mr. Rivera.
Thank you, Mr. Chair. So I have a few questions. I'm just going to vomit them all at once, and then feel free to respond just out of respect of time. So I've heard from the administration a couple of times today about how this is a tool to help leverage to get cases to resolution, and about the current system possibly compromising the ability to prosecute cases. Are you able to speak to how many cases you feel have been compromised because this is not a tool that you have in your toolbox? Second is, I'm still a little bit confused about the how pre-SB 91 this particular provision was enforced, and in particular, I'm just wanting to learn more about, in instances where people went to jail for an FTA, what that looks like. Because if I'm understanding correctly, there's a sort of a consecutive to the full sentence. So I just want to understand what that looks like. Or if we're talking about 2 days in jail and then maybe later they'll spend the rest of, if they get convicted, right? Or what that looks like. Then third question is around demographics. Would anyone in the municipality be able to pull data from 2019 to today, so post SB 91 to today, on essentially how many per year, how many of those were repeats, because I've heard that issue come up, and then any basic demographic data of the individuals who were convicted, or whatever the right term is, of FTA. Thanks.
I would just add one little to that, and I just want to know an assessment of the number of times they believe this will be charged annually. So all of those pieces plus one piece, your projection.
Going backwards, I don't know that we track. Well, I would have to ask around, and I don't have ready access to demographic information. That's something we track. APD tracks that through their reporting and all that stuff. And again, we haven't been charging it for all these years, so there's nothing to track. But I would have to approach the court system if they have any tracking about what they're doing as far as bench warrants getting issued, or whether they track demographics in the first place. So a big I don't know as to the demographic questions. As to has this compromised our ability to do our job? I would say it would be one piece among others that has snowballed into making it very difficult to do our job, in the sense that this is a totally separate thing from the COVID, but the reality is that cases are dragging longer. Part of that is people aren't coming to court. Part of that is the court's not built for telephone court the way they've been running it for the last few years. That's difficult and inefficient. That's also going to make it so we can't charge these crimes initially, because people just simply aren't coming. That's starting to change now. And again, that's part of why this being the tip of the spear for trial, that's why that matters, because that's when people are physically, you have to come for your trial. You don't have to come to the big cattle call hearings because there's hundreds of people, but for you, when you actually want a trial, you're supposed to be there. And when you don't show to those, that's also when it costs us and the rest of the court system the most in far as time and money, in the sense that when someone demands a trial and doesn't show up, you've not only wasted the judge's time, you wasted jurors' time who were compelled to be there. And that's far more prejudicial to us doing our job and to just everyone else in the public in general, when those are the times that people are not coming.
Thanks. So just out of respect for time, you didn't address my jail question, but that's okay. If you can do it quick.
Answer is basically not significantly, in the sense that, again, like I said, we're not here for FTAs. If someone is convicted of their underlying charge, they will get whatever jail the court feels is appropriate. At the end of the day, if they're also convicted for the FTA, that's not going to result in, I can count, even when this was a crime and we were doing this, it was maybe 5 days, maybe 10 days of actual time to serve on top of whatever else was going on. Usually it's just additional suspended time on top of the rest of their charges. So it's not something that's resulting in, again, they were already arrested on their bench warrant. They probably already served that time. So it's not, I've never personally seen it where it results in significant additional jail time imposed on anything else that wasn't also the underlying crime. That's why we're here.
So I have myself in the queue, and it's really the same question, just asked slightly differently. And I don't need an answer today. I need an answer by Tuesday. And you say 10 days or 5 days, and it maybe or may not add to the sentence because there's an underlying charge, but we're adding this because clearly we're being told there's a need. So the question really is, from a projection basis, what are the number of times you think this will happen in a year? And I know that might be hard to give us an assessment of, but if we don't have a sense of that, it's really hard to know if this is a cat chasing its tail or if it's an actual need. And then the converse side of that is if it's a lot of them, then there are actually fiscal notes that apply. Because if we are enhancing sentences with 5 and 10 days per person who is charged and it's a sufficient number, then we're going to have to pay for more jail time because we do pay for those things. And that's a fiduciary responsibility we have to understand what's happening. And so, and oftentimes I think those charges are black boxes that the assembly doesn't really have a sense of because it's just kind of wrapped in and who knows where that really shows up. But it shows up somewhere because we don't get that service for free from the state. And so really I'm hoping by Tuesday we can have a table that's added to this that is kind of our analysis of what we think the number of cases a year are going to be charged under this. And I recognize we didn't charge it going backwards because we didn't have it, but we were told that there's this failure to appear ticket. And so probably the basis can be on however many of those tickets were issued. If we weren't issuing those tickets, then the question is, why in the world would we add a criminal sanction if we weren't using the tool that we had? So there's a lot to kind of chew on in there. And I'm not necessarily objecting to it, as I've said before. One thing, this isn't personal or about this policy change. Every time a Title VIII change has come before this body since I've served, it has gotten strict review, like very close scrutiny, because we're talking about criminal sanctions against people. And so when we are using the police power of the state to create criminal charges, we look real close because this has impacts that we might not be able to understand. And so for my part, I hope by Tuesday, with enough time to chew on it, we would have some basic projections to understand the actual impacts. Do you need to be in the go now or in the queue, Mr. Gates? Because I still have a couple people. Okay, thanks. So next it's Mr. Johnson.
Yeah, thank you. I certainly, I'm fine with these questions of trying to gain additional information and context. I'll say for my part, it doesn't matter to me personally how often we use it. It's whether or not it's fair and good and feels appropriate. I mean, if it's a tool that's rarely used but is in the interest of justice, I respect that. I still think it merits consideration. If we want to do an analysis of what is the additional cost because we may be adding sentencing in certain cases, then let's consider that. But I think with that, we should also look at what is the cost, as you point out, to the court system, to the prosecutor offices, to jurors' time when people don't appear, right? Because if people are failing to appear, there's a cost that's associated with that as well. And if we think we're going to reduce that cost because people are more inclined to actually show up for trial, then I think that should be taken in consideration and potentially weighed against what the cost is, the additional jail time. I mean, I don't know if I will ultimately find that all compelling because ultimately it's whether or not this consequence feels fair and just. And I think in the cases you've outlined and recognizing that the harm this does to your ability to prosecute cases and the harm it does to victims, frankly, it makes sense to me. The question I did want to ask though, so right now it's a violation and usually violations when the conduct occurs, they're issued automatically, I guess. The person is cited. And in this case, today it's a $1,000 fine. But if we are making this now criminal statute again, then it feels like there's actually going to be more discretion potentially at play. And you talked about there may be different circumstances that the prosecutor's offices might consider in determining whether or not to charge a person with failure to appear. So, we would certainly, I would hope that this tool would be used, in which case this person is willfully or for a protracted period of time, wasted the court's time, chosen to fail to comply. But there may be cases in which it's not, for whatever reasons, we think there's a sympathetic reason why somebody failed to show up. So in those cases, would we actually have more discretion with this change about the penalties that may or may not be applied because it is now up to, I would think, more the decision of the prosecutor as opposed to simply issuing a ticket automatically when someone commits failure to appear today. Does that make sense?
I think it would result, well, number one, my people don't have any discretion because they're not being asked the question. And so it would give us the ability to accurately respond to the situations that are brought to us, in the sense that, yes, go ahead.
So I guess just to put a little bit of a finer point today somebody might be charged $1,000 for failure to appear automatically, whereas if the circumstances were understandable, the consequences might actually be less in some circumstances.
Yeah, most definitely. And again, I didn't know what those numbers were. Apparently it was 12 this year, but how and when APD is deciding to issue those citations, I don't know, because it's not my people doing it, but it will be my people doing it when they decide whether or not to charge crime. And APD won't be the ones making that choice up front. It'll be us doing it on the back end.
Mr. Gates.
Oh, well, and I was simply going to mention that the history notes to this offense, it's on page 3 and 14, the ordinances that have changed this code section throughout our, I guess, municipal history. I actually pulled them all up during this work session, and that level of offense has changed a couple times. So I was just going to mention that the last time it changed, it was changed from Class B misdemeanor to a minor offense. That was 2016 83S, and that was required by SB 91. So this ordinance just changes it back from the last time the offense was changed in code. But for each of the other changes prior to that, it's a little interesting. But in the interest of time, I'll just bring this information to the sponsors and they can share Tuesday.
Thank you. And I have myself last thank you before we go to Ms. Halser at the end of this meeting. And it baffles me to think that there are citations happening in active cases related to people that the prosecutor's office is actively prosecuting, that the prosecutor wouldn't know that they were cited and had additional penalties against them. I don't understand how an argument could be made that your prosecutors wouldn't know that, because my guess, maybe I'm kind of naive here, but when a court view record is created for a case that exists for a person we're moving to prosecute, the prosecutor would know what's going on in court view. I know when I have a case I'm interested in watching in court view, I see everything that happens. And so I don't know that that adds up. I think that we should know, but there is that other issue of staffing, vacancies, like a lot of our city government running on a treadmill, trying to keep up to the tail that keeps getting farther away of the work that has to be done. That's a reality that we all have to grapple with. So more information is better. Ms. Halser, you have the floor to close us out.
Well, through the chair, I'm not going to take much time up at all. I just wanted to, this issue, failure to appear, it is something that I think could be improved overall. It's good for people to have the obligation to show up in court. It's accountable. It encourages accountability. It encourages responsibility for whatever occurred. And so I agree, there's not potentially a whole lot of moving the needle here, but there is a message being sent. And that's all I had to say.
Thank you. And this will be before us on Tuesday, depending on how thick the agenda is. We should get to it, and more information is helpful to getting folks who are on the fence still to a yes. And if there's nothing else, we will adjourn. Take 10 minutes before the next round. Thank you, everybody.